So today we're going to be discussing a class that I've given a couple of times before, and it's still relatively new, so I'm kind of tweaking it as we go. But it's something that everybody who handles claims needs to understand, and it's something that's very rarely taught. As we'll see, a lot of times what adjusters know about claims handling is the shortcut method of what their attorneys are telling them is the law. And where that causes a problem is that if you, as the claims handler, do not know how the attorney got to that point, how can you use that information when you don't have an attorney? You need to know some of this, I guess you could call it legal stuff, so that you can handle claims without an attorney effectively. This entire case came as the result of a case that I had for a long-term client. I got the claim, Patrick, can you figure out what's going on in this claim? And no offense to the adjuster, she's actually very good, but she had made some crucial mistakes that, based upon what she had been taught, not by me, but what she had been taught, is perfectly in compliance with how things had been taught to her as to how Louisiana works. But from an attorney perspective, those items could not have been more wrong. And so what could have perhaps been a $5,000 go away case wound up being a six-figure settlement because these items were missed. There was a lot of presumptions involved, and there was no way out of it by the time it came to me to be handled. So I decided to prepare this class. I believe I gave it once last year, recently at the Southwest Claims Association meeting, and probably once before. And it's something I'm going to continue to teach until everybody starts to use the presumptions in their claims handling process. So let's get to the good stuff. Where do we start? It's a matter of burden of proof. So everything in the law, it's not written as we teach it. It's not black and white, yes or no, good or bad, them or us. It is a matter of burdens of proof, okay? We win unless they do this. They win unless we can do this. Okay? So, like, for example, when you start off, the plaintiff has the burden of proof by a preponderance of the evidence that he suffered an accident, course and scope, and all of that. If you had to measure that, the claimant, who has the burden of proof, has 49% of what he needs to win. Because we do not have the burden, we're automatically at 51. Okay. If that I had an accident, we go to trial. Okay. Now, there's a lot more to it because accidents are a lot more nuanced than that, but just weighing that burden, the person with 51% chance has won. Just to give you an example. So one of our partners here at the firm recently tried a case, variety of issues. And one of the issues was that the claimant was permanently and totally disabled, and they're entitled to permanent and total disability benefits. Remember, they're two different things. So the allegation was made. Claimant put on their case. They argued accident, course and scope, everything they needed. And they said, and she can't work. And then rested her case. Okay. She had put no evidence on that her client was completely unable to work in any capacity, which is what you need for permanent total disability. Our partner realized she hadn't put forth enough evidence. She didn't meet her burden. So he asked for a directed verdict on the issue of permanent total disability. Your Honor, she's got to win by, it's clear and convincing. So she would have to win by, say, 60%. Your Honor, she's got to have 60% evidence. She hasn't put on anything. I won. And the judge agreed. He did not even have to make an argument that she was not permanently and totally disabled because she never met her initial burden. And trust me, I am getting to a point that you need to understand. So every element is subject to either a preponderance, okay, 51%, 49%. Clear and convincing, maybe 60, 70, 75%. Okay. And then there's beyond a shadow of a doubt, which you simply don't have in common. The person who has the burden, who has to meet that burden, they have the burden. Okay. They must satisfy the burden. If they have done what they needed, they have carried their burden. They have satisfied their burden. Okay. They have met their burden of proof. You can also, looking at certain presumptions, shift the burden of proof. I originally have the burden. I benefit from a presumption. The burden of proof then changes. I'm no longer proving X. Okay. They now have to prove it. And that's what's critical. Why do we have presumptions? Because some things simply cannot be proven. And the court cannot live with an unanswerable question. Judges simply cannot, if you're old like me, call Mr. Peabody and take a ride in his Wayback Machine and go see, did the claimant actually suffer an accident? Okay. They don't have the ability to watch it occur in real time. So the most common situation we encounter and where presumptions come into play is aggravations of pre-existing injuries. We have all been taught that aggravations of pre-existing conditions are automatically compensable in Louisiana, and that is false. Adjusters have been taught the shortcut method, but have not been taught how attorneys get to that general statement. We recognize it's not always automatic. Well, we should. But when we try and condense this information for adjusters, because they have a lot to do, we try to give them workable rules that cover a majority of situations. Sometimes they are too broad, and the adjusters are not provided the information that they need to know to make that decision. Is the aggravation compensable? Sometimes there's a burden in play and it's shifted. So that legal presumption, it's a tool that courts have. It allows them to reach a conclusion based upon a particular set of facts or logic or reasoning that would suggest it would be true. I'll give you an easy one before I get into the tough one. The treating physician's presumption, and we'll talk about that. In Louisiana, the treating physician, their opinions are presumed to carry more weight at trial because the treating physician has treated the claimant more. They have a closer relationship. They have seen their complaints wax and wane. They have seen it for months and perhaps years over the course of treatment. So that treating physician is presumed to have a clearer picture of the claimant's medical needs. So the court, by reviewing the presumption, will default to what the treating physician says. They are going to presume the treating physician knows more. The court is not going to look at who graduated top of their class. They're not going to look at who has the most specialties or who wrote the most articles. The court does not have the ability. So when the court is faced with an opinion of a treating physician and an SMO, a presumption has to decide who gets more weight. Treating physician presumption says you got to go with the guy who likely knows more. So the court is going to look at that. So you see how presumptions help the court reach a decision that they cannot do on their own. Now, we're not going to talk about this one, but it is another one you encounter daily. The 40-hour presumption. It is a presumption. The presumption is that if the employee is hired for a full-time position, that equates to an expectation in the mind of the employee that they would have been provided 40 hours. The law actually says 40 hours. And so the court, we have this situation. Did he really want to only work 38 hours? He's going to say he wants to work 40. We say, look, he's worked nothing but 38s. He's going to say, I wanted to work 40. I was full-time. 40's full-time. That's where the presumption comes into play. The court's going to presume that he would have worked the 40 hours he was hoping to work. The court takes away what was really said, what was promised. The court doesn't have that information, so they're just going to put a presumption in play that someone who applied for a full-time job was expecting to make 40. So that's a presumption in play. The court can't read minds to find out what was actually thought, said, spoken of. We're just going to go full-time 40. It is a presumption. Okay. Now, a presumption, well, let me go back. A presumption can be rebutted. A rebutted presumption is when you can prove the presumption should not apply. Okay. For example, let's go back to the 40-hour presumption. Claimant says, I'm entitled to the 40-hour presumption. Okay, I want my hourly wage multiplied by 40 hours. Okay. Okay, Patrick, you've got the 40-hour, you're stuck with the 40-hour presumption. He's got the benefit. What are you going to do? Well, Your Honor, here is a page signed by Mr. Jones where it says, I don't want to work 40 hours. I want a schedule based upon 38 hours per week only. Okay. The judge, likely looking at that, knows that the claimant chose to work less than 40 hours at their own discretion. And so I have, if the court accepts it, rebutted the presumption. That presumption does not apply. Okay. So the hourly wage is based upon his actual earnings. And now he has to somehow convince the court, because now he has to meet the burden that he should benefit from 40 when I've got this saying he wanted 38. So burdens are who has to prove the existence of a thing. If I've got the burden, I've got to prove the thing. If I prove the thing, the other side now has to prove that I should not have benefited from proof of that thing or that it doesn't exist. Look, we take months to learn how this works in law school. But I just want to focus on 3 that we use commonly. And just to give you some that you think of automatically, but you don't actually see them as a presumption. You see them as the law, but they are in fact a presumption. A child born of a husband and wife living together are presumed to be the natural child of the husband and the wife. Okay. They don't know for sure, but it's presumed. It is a rebuttable presumption. So how do you rebut that? DNA evidence that shows the husband is not the father. Okay, that's not the law. That's the presumption in play. DNA evidence showing he's not the father, the presumption goes away. But if there's no DNA evidence, if there's no evidence one way or the other, then the court is going to go, well, if you guys were living together at the time of the conception of the child, then, and the birth of the child, we're going to say, yeah, more likely than not, then that's your child. The court has no way of actually finding out the answer in those circumstances, so they create a presumption. A person who has disappeared and not been heard from for 7 years is presumed to be dead. Okay. 6 years, 11 months, that person is still alive in the mind of the court. Okay, the presumption has not arisen. 7 years, 1 day, the presumption falls into place. It shifts. The burden of proof has shifted. Is that guy dead or not? 7 years, 1 day. Okay, it's presumed he's dead. Now, if you want him to still be alive for, say, the will, a will or something, then you've got to prove that he is. You've got to go find him, because the law is now saying the burden has shifted. He's dead unless you prove otherwise. A person is presumed innocent until proven guilty. We all know that. You see how it is. There is what the law says, that everybody's innocent. They are presumed innocent until they are proven guilty. If you don't know how the presumption plays out, then you will focus on the end, the conclusion. And if you don't know how you got there, you don't know if the presumption has been rebutted, and then you wind up making a wrong decision. And I'll show you how it all played out. This is one that I believe every adjuster needs to know and keep in their bag of tricks. It is called the presumption of causation. Is the injury claimed by the employee related to the accident? How do we know? Let's take, for example, a gentleman who has a degenerative condition in his low back. He's going to say, yes. Okay. Someone who's sitting in, so I'm just going to jump right in. So the employee says, yes, this accident made my back start to hurt. We're going to get that in right, and it's going to have a slew of degenerative conditions. Okay. Are his complaints the result of those degenerative conditions? We know he didn't cause them. How do we know that that accident made those complaints arise? Again, what does this sound like? Aggravation of pre-existing condition. We hear it, we've heard it for years. It's automatically compensable. The aggravation you're stuck with. And that's what happened in my case. Or it happened in the case that I later got after the decision had been made. So for a claimant to recover, they have the burden of proof to show that their complaints are related to the accident. But there's no way for the court to know. So if there is something seen on a post-accident MRI, unless it's absolutely traumatic, let's say a broken bone, but if it's something in the spine, how do we know that it was caused by the accident? Well, the only way to know truly is, was it there before the accident? Well, if the guy gets hurt on July 5, in what world is he going to have had an MRI performed on July 4? None. We simply don't know. The court is left with an unknown. Was it there before? Did he truly have pain before the accident? He's got degenerative conditions. He's saying that the accident made it symptomatic. How do we know if it was there before? If the court stuck to the burden and there was no presumption, most claimants would never be able to receive benefit because they wouldn't be able to prove that the accident caused those complaints to arise. It would become a credibility issue, as the court believes. But the court's going to want some medical evidence for a situation. So the presumption of causation is created. It assists the court in answering the question, are these complaints related? It is not merely aggravation equals compensable. No. To determine whether the aggravation is compensable, the court has to determine whether the complaints are actually related to the accident. So that's one of the things that was missed in my other case. The adjuster saw aggravation and simply approved treatment that later resulted in a surgery. Didn't catch that the claimant had treated with that same clinic for 3 years prior for annual lumbar ESIs. He had ongoing treatment prior to the accident. So let's see how it played out versus how it should have played out by looking at the presumption. If before the accident, the injured person was in good health, but commencing with the accident, the symptoms of the disabling condition appear, and continually manifest themselves afterwards. 3, and the evidence is sufficient to show that it's a reasonable connection, then the court will presume accident caused that condition. We have to look at each one individually. Yes. If before the accident, the person was in good health, let's say the claimant's health before the accident, why do you think your attorneys put so much effort into looking at the claimant's pre-accident medical history? Because they are trying to prevent the presumption from applying. If the claimant benefits from the presumption, he's no longer proving the accident caused his complaint. We must then prove that the accident did not. So in every single claim where there is no traumatic accident, a broken bone, well, it wasn't broken before, it's broken now. Okay, yeah, we don't really need to get into causation questions there. A burn, a traumatic amputation, you know that accident caused it. But I lifted a box in my back, started to hurt. Those constitute, I would say, probably 80% of every claim that comes across a claims handler's desk. That's a presumption evaluation that he must perform. So first thing you do, got to know their pre-accident situation. Were they pain-free before? Had the accident pain happen? You got to know what they were before, but your options are always limited. So the court's going to look at their claimant immediately before the accident. The longer you get away from the accident, the less effective anything you find will be. A day, a week, a month, 2 months, 3 months. That's still going to be useful. So that's why we say, oh, it's 2023, a 2016 back complaint is likely not going to benefit us. There's no rule that says that. But the presumption is going to look at their health immediately before the accident. So 2016 is not going to be in there. So we don't just ignore it as a matter of law. We know it's not going to affect the question of what was his health before the accident. So if there's no active treatment, not going to his doctor, there's no testing, he's not getting pain medication, the court's going to presume the accident triggered it. Doesn't answer the entire question. Did it trigger the event? So how do you, as a claims handler, attack that? You don't have subpoena power. You can only get limited information. There are a few things you can do. Conduct that comprehensive recorded interview. For those of you who are new to the channel, we actually have a discussion between myself and one of my practice partners, Corey Moe, on how to conduct a proper recorded interview. It is so much more than just working from a script. You want to focus on what was their health immediately before that. That's not a one question inquiry. So tell me about your health before the accident. Any complaints in your low back? No. Any at all? No. What about like aches and pains, just normal, my back hurt before that you didn't feel like you needed to go to the doctor? Anything like that? No. So let's just say 3 months before the accident. How was your back? My back was fine. Okay. When was the last time you went to the doctor before your accident? Any doctor? 6 months for my checkup with the doctor. Did you talk to him about any back issue? No. Well, maybe you find some. But you should know with that it's looking like, assuming he's honest, there's nothing there. So you kind of have to start looking at, well, maybe he's going to get this as part of the burden. I'm sorry, the causation. Sorry, the presumption. But what if he says, well, yeah, I mentioned to him about 6 months ago that I was having some back tingling. Okay. Will that be enough to defeat this element? It may be. You don't just go to the doctor and say my back hurts and the complaints just automatically go away. there's the likelihood maybe there's some lingering treatment. Did that doctor give you any medication? Did he send you for any tests? Did he send you for a doctor? Okay. Remember, in a recorded interview, you're not looking at the script. You're following the answer. For the medical records you do have, read them in detail. The case that prompted this seminar, the record immediately after the accident was follow-on visit, not an initial visit. Doctors get paid more for initial visits than they do for follow-ons under the fee schedule. That should have tipped her off. There's probably something I don't know about. Okay. Also, the first visit was with the pain management doctor. Who treats with a pain management doctor? Someone referred to a pain management doctor by an orthopedic surgeon or a neurosurgeon. He should have caught that there was probably an orthopedic surgeon or a neurosurgeon involved. In the HPI, history of present illness, it talked about a previous L5S1 ESI 3 months before the accident. He mentions annual ESI in his low back. Our injury was low back. Okay. So he went right to the bottom, aggravation of whatever the specific diagnosis was in the low back. She saw aggravation and thought, okay, it's an aggravation, and ran with it. Everything up in the HPI screened. This guy was going back for a regular scheduled visit with his pain management doctor that was likely sent by his treating physician, who was an orthopedist. We found out later. Okay. You have to go that detailed into the medical records and see if it suggests ongoing treatment. Speak with the employer. Oh yeah, that guy's always missing work for back issues. Okay. My employer knew that he took off annually for some sort of back injection, then he missed like 2 or 3 days afterwards. Okay, that wasn't asked. Again, that information is out there to the adjuster. You don't need an attorney to ask this. Run the index report, look for hits on prior accidents. If you do get a release, sometimes they give you that broad release. At least go look at hospitals. A lot of people who don't have private health insurance or who don't want to pay a deductible, let's be honest, will go to the emergency room. That is their primary care facility. If you have a blank one, go to the hospitals. Look at pharmacy records from CVS, Walgreens, Walmart. That's most people's primary prescriber of medication. Go get those as part of a small canvas. When you attack I was pain free for the accident by proving he was not pain free, supporting it. Because here in my case, I would have argued, Your Honor, it's not a case where we are proving the aggravation didn't occur. They've got to prove the aggravation did, because they don't have the presumption because he was treating before the accident. Okay. But commencing with the accident, the symptoms of the disabling condition appear to continuously manifest thereafter. So those complaints have to arise almost right away. That's why we are troubled as attorneys by complaints that arise 3 to 4 days later. Because the presumption wants, I guess in a way, the presumption presumes the complaints arise immediately. So they also have to continually manifest themselves thereafter. So I have a case that hurts his ankle, treats for 6 months. Then there is, according to his deposition, 4 months in which he is completely and utterly pain-free, according to his testimony. And then one day, he steps off of his bed and his ankle hurts him. So I'm arguing, yes, Your Honor, while I recognize he has the presumption of causation, it exists in his favor only until that break in treatment. Because to benefit from the presumption, his complaints have to continually manifest themselves all the way through. So, if when you're looking at the body parts, if they don't come in immediately, question them. because it may be a situation that they don't benefit from the presumption. Okay. I'll give you another one, really confused. Going to trial in a couple of weeks. We know the plaintiff was treating for his neck 2 days before his accident. Okay, so I'm going to argue and continue to treat for a few days after with his regular one. So I'm going to argue he does not have the presumption of causation for the neck, got degenerative issue. So I'm arguing there is no aggravation because he was treating before. There's no way to tell whether it made it worse. So he's got to prove it did. I don't have to prove that it did. But in the same medical records where he's complaining about the neck, he doesn't mention anything about the back. So he has the benefit of the presumption for the back. Okay. So while I'm arguing he was complaining about the neck before, he can't prove an aggravation. Those same records prove that he gets the presumption for the back because he had the opportunity to complain and he didn't. The court is going to assume that he had no complaints because he's at the doctor's office and he didn't say anything. So in a weird sort of way, I have to prove the back was not aggravated. They've got to prove the neck was. Why that's important is because as an adjuster, when you start to evaluate risk, you know where the risk is. In this situation, that back, yeah, we may be stuck with it. For the neck, you know what? We may fight that. You don't, and look, both records, post-accident, aggravation of neck, aggravation of back. Okay. My adjuster did not assume that they were both related. We found out about those other records fairly quickly. So we're not accepting the neck, but we're accepting the back. Well, we're sort of acknowledging the back is probably a loser, but we're not accepting it because of the accident. But that's how the presumption plays. As an adjuster, when you're starting to weigh risk, you're starting to weigh reserves, you're starting to weigh where do I need to put my limited time into a claim. But with that back's going to be a tough fight. So you're looking mostly at damage mitigation. Okay? I need to fight against the surgery. I need to fight against treatment. I'm likely already stuck with the back as mine. You know, if you find something great, but understand you're likely stuck with the back. But for the neck, that neck may be yours, but they've got to prove it. Okay. So you want to build up whatever you can to make sure they don't get the presumption. Go deep into those medical records. Find out the extent of medical treatment pre-accident. Build it up so they can't benefit from presumption. It just so happened that the doctor, once he learned a treating physician, once he learned about the prior that treatment, said, I can't say it's related because of the extent of treatment on the eve of this accident. Back, he said, oh yeah, if I don't have any evidence of back treatment, then yeah, I would have to say that it's probably related. So when you know how to play the presumption and use the presumption of causation, you can better dedicate, that limited amount of time you have as an adjuster. Okay. So how do you attack it? You separate those events that arise immediately versus those that come in later. Okay. Separate those two. Where do you push your time? Challenge those complaints that arise later in a claim. You have a better chance of defeating those. Okay. Sometimes attack that portion of the presumption by credibility attacks. Oh yeah, yeah, it was hurting all the way to day one. Yeah. Medical records show it. Day one, nothing. 3 days later, you went to the doctor, there's nothing. Okay. Look at the history given to the physician. So I had no back complaints prior to the accident. There they are. You may get a fraud defense. Or you may know, wait a minute, I'm not dealing with I've got to pay for a presumption. He now has to prove it. You lock the claimant into the events in the recorded. Remember, one of the things we push in that recorded interview class is you have to lock the claimant into a cage around his story. is their story will grow. Gotta lock them in early. When did this complaint arise? Okay, great. When did that complaint arise? Okay, when did you first notice this complaint? So Mr. Jones, so did your back hurt right at the time of the accident? Yes, ma'am. Okay. Did it ever stop hurting even for a little while? No. So it hurt the same all the way through to today. Yes. Is that what you told your doctors? Yes, ma'am. Okay. Now, when did the neck start to hurt? Actually, that started like maybe a couple of days later. Okay, how many days? About a week. That didn't arise right away, so start to focus on that. So no complaints? No, I didn't have any complaints for that first week with my neck. Well, if you hurt your neck, don't you think you would have had some complaints? And you don't say that, but that's how you start to begin to think about it. Okay. You may have the presumption in his favor on one, but not the other. Put take your time into how you fight each individual case. You're going to fight them differently. You don't fight them the same. But when it comes time to how you allocate resources, you now know which one you have an uphill battle and which one they have the uphill battle. The effect of the presumption. So if they do not benefit from the presumption, aggravation of pre-existing condition, that's what the doctor said. You know he was treating for that same body part continuously up to the time of the accident. Or he wasn't treating, but the complaints didn't arise for 2 weeks. Or he was not treating before, they arose immediately, but there was a 6-month gap in treatment. That's your attacks. Okay. You can limit it. Otherwise, if you go in with aggravation equals $, $, and not worrying about that, if you had complaints before the accident, you missed it. You're treating it as presumptions are always aggravations are always. If the complaint doesn't arise for 2 weeks after that, but you see aggravation always compensable, you missed that. What if there's a 6-month gap in treatment and you just see aggravation is compensable? Okay. Maybe the triggering of the pain starting again was because of another event. No longer yours. It started because of something else. So you have to, every time you don't have a traumatic accident, you have to look at the presumption. I'll give you another example. I had one where 2 years, maybe a year and a half after the accident, the doctor wants to start treating the shoulder, right shoulder. That complains the whole time. Low back complaints. Well, I have been thinking of this as a neck and back claim. Then we get a 10-10 for the shoulder. I immediately know there may be a presumption fight. Because if there are no prior complaints of the right shoulder, I'm arguing it's not ours. I get back in the medical record. He's got a right shoulder complaint 3 years before our accident. He's got multiple left shoulder complaints for the accident, but no right. Okay. He falls. Right shoulder hits the ground first. Okay. So it's probably with the accident. First medical record post-accident and right shoulder. He starts treating with the doctors. It's sometimes a right shoulder injury as a separate body part or cervical pain referred into shoulder. So the doctors treat it up as the shoulder is really just part of the neck pain. Once they cut on the neck, shoulder pain still hurts. They think, oh, now it's a shoulder issue. And if you go through the medical records, no right shoulder complaints before, right shoulder complaints immediately arise. Right shoulder complaints are always discussed either as a separate body part or as referred pain from the neck. Now they want to treat the right shoulder. Guess what? That's our right shoulder. That's simply looking at how the presumption will play out. It's not automatic. The doctor wants it, pay for it. Let me do my examination. Yep, he's going to get the presumption. We're still going to fight it, but we're going to let him have the initial treatment. These are ways you attack it. A lot of it comes from my attack, but you are going to make the initial call. There are some things you simply can't do when you recognize. But once you know how to fight this presumption that is in every single case you have, that's not absolutely traumatic. You can do certain things. You're not just left on your own to guess. Don't just go with aggravation equals I pay. Do your due diligence. Raise your questions. Put your concerns in your claim notes. If you argue, I don't believe this because I don't think he has the presumption, here's why, that's going to carry weight. For those of you who were here when retired Judge Larimore was sitting right here in the first class, and I asked her, what would you do, Judge, if a judge said, if an adjuster said they're not accepting that body part because they don't believe the claimant's going to benefit from the presumption of causation because of this? She goes, well, if they're right, I'm probably not going to get them for penalties and attorney's fees because that's a reasonable basis. I'm like, even if you award that body part? She goes, yeah, they did due diligence. They had some serious concerns. Okay, not right or wrong. Were you reasonable? Did you evaluate this through the lens of the presumption of causation? Treating physician presumption, as we talked about. How do you attack it? Proactive use of second medical opinion in early. For those of you who don't already have a copy, we have a best practice guide for claims handling. I think it's the first one. How to use your second medical opinions tactically. Okay? How to use your SMO offensively, not as a defensive tool. Use your SMO and you go on the attack. Okay? Get them in early. Because remember, treating physician, the more they treat, the less effective your SMO because of the presumption. They are not viewed as one for one. I get this all the time where Patrick, he can work. The SMO said he can do what I do. What does the treating physician say? No. How many times has he trained the treating physician? Oh, about 2 years. Yeah. You can't put that guy back to work. You don't think that's the case? There's a new case that came out yesterday that said the exact same thing, or a day before yesterday. Treating physician said light duty. IME said light duty. Both rehab jobs were found. Treating physician says can't work. Appellate trial court says, yeah, he can't work. Appellate court said, you're right, treating physician can't work. They didn't speak of it in presumption terms, but the court felt it was sufficient enough to say, but the treating physician said he was unable to work. That's basically applying the presumption without actually saying it. So, review the claimant's history. So, you want to see what did he tell the doctor versus what he told you. What's in the medical record, the credibility challenge. What you're trying to do here is by proving the treating physician says X based upon this information. The SMO says the answer is Y, but the SMO has more information. So, treating physician is likely only going to have his record and his studies. SMO is going to have what? The SMO's records, the claimant's primary care physician, the claimant's ER record, the claimant's pre-accident studies, if you have. The SMO is going to have more than the treating physician. So you're fighting that game or visits you have with the treating, the scale's going to tip in their favor. My SMO has more information than your doctor, the scale's going to start to tip back. You want to get your SMOs done early because that sort of balances the scale. Your SMO may be 2-3 visits behind and not 21. And then as you get new information, you send it back to the SMO and go, look, can you write me an update if you think it changes? Okay. No, Patrick, none of this changes. You go in and put it in the report? No, doc, that's fine. Or, yeah, I think I need to comment on this officially. Okay. Remember, SMOs are not just actual visits. SMO offering an opinion based upon new studies counts. As the treating physicians racking up visits and getting new studies, those studies should still be going back to your SMOs and asking for comment. in. The longer they treat, more SMOs and IMEs you're going to need to try and balance those, scales, or they're going to win simply because the number of visits. Or you attack it by saying, my doctor knew something, your doctor didn't. Undercut. It's not impossible, like unless you are, and I'll just say it, at least in Louisiana, the Louisiana adjusters recognize to a somewhat greater degree that the SMO is not all powerful. We're not going across into Texas where, they have the designated doctor. It's not that kind of power. It's just almost a different medical opinion. And you have to make it become more valuable. It's limited in the value as it exists. But you, as the claims handler, have to make it better. You have to make the SMO better. You've got to give them more information because it's not just weighed based upon his being the SMO. Specialist presumption. You don't see this often because you're normally dealing with a orthopedic surgeon versus orthopedic. The court's not going to look at class rank. So doctors of a similar specialty are usually going to be treated about the same. Maybe you can luck out occasionally by saying, my doctor's board certified, yours not. Okay, my doctor's been treating for 30 years, your doctor's been treating for 5. Maybe that works. But specialist presumption really comes into play, and you've got to be careful because it's backfire. Hey, Patrick, I got a new case. Okay, I need a second medical opinion for a chiropractor. Yeah, those don't. What do? Go get an orthopedic surgeon. We will argue that an orthopedic surgeon, no comment on chiropractor, but when you're dealing with a, let's say, a spinal injury, an orthopedic surgeon, a neurosurgeon, so our mind is going to have a greater degree of knowledge about the inner workings of the spine than a chiropractor. So the court should give more weight to the orthopedic surgeon, the neurosurgeon, than that of the chiropractor. So even though the chiropractor may have seen him 20 times, and you have the treating physician's presumption, Judge, my doctor's a specialist in treatment of the spine. So that treating physician presumption can go out the window. Specialist presumption applies, and I have had the court give more weight to the treating physician to the specialist, the orthopedic surgeon who trumped the chiropractor. Now, I was trying to force what happened next. They then went and got an orthopedic surgeon. That orthopedic surgeon issued a report. Patrick, the orthopedic surgeon says that he can't work. I said, fine. I sent that report to my SMO, and the SMO issued another report saying, after I've reviewed the opinion of Dr. So-and-so, it still remains my opinion that Mr. Blaine can continue to work at medium duty. And I refuse to let the plaintiff have any more treatment with his orthopedic surgeon. Okay. But guess what I bought with that? I no longer was where I used the treating physician, the specialist presumption against the chiropractor. And as against the treating physician, I had an in-person SMO, and my SMO then reviewing his report. So I picked up the treating physician, basically a different version of the treating physician's presumption. I actually prevented them from applying it. Okay. So the big things to take away, and this is it. Your time as an adjuster is limited. We know that. Admittedly, as attorneys, we sometimes we aren't as understanding as we should be. Let's be honest. But as an adjuster, you do not necessarily have the time to give each individual claim. You don't have one claim. You have 100, 150 claims. different plaintiff's attorneys, different defense attorneys, different judges. Okay? How do you break up your time? Well, once you understand the presumption, you know where certain fights can be had, especially when you have been taught, unfortunately, over the years, that, oh, aggravations are automatically compensable. Many people, oh, if it's an aggravation, they don't put any fight into it because they know aggravations are automatically compensable. Whatever my SMO and IME says, the court's not going to care because aggravations always win. But not if you know how to attack the presumption. So don't just put aggravation claims on the shelf, figure you're not going to win. Don't just green light treatment until you get to a point that you think you can settle. Look at the aggravation claim. Can I attack the presumption? There is nothing in Title 23, the Workers' Compensation Act, that says aggravations are automatically compensable. There is simply no such language. Courts have said, in the absence of any other information, we are going to assume that there was an aggravation. They reach that opinion by using the presumption. Sometimes courts reference it. Sometimes courts rely upon it, but don't reference it. But understand, in every aggravation claim, they have gotten there by using the presumption of causation. And you can attack that. So don't just treat aggravation as compensable. Evaluate it. Can I fight that he had complaints before? Can I point to those complaints did not arise immediately? Can I show a gap in treatment? Am I dealing with one body part that has the benefit of the presumption while the other one does not? Again, you have limited time to manage it and use it productively. It's not going to, it's not, this is how things are going to play out. You can't predict what the judge will going to do. But once you know how the presumption works, you're going to get much, much better at properly setting reserves. If you know that we have rebutted the presumption, they're arguing aggravation, and we have pre-accident complaints, and the complaints don't arise immediately, they've got to prove it. Are you going to reserve that file the same way as you would a claim where you have nothing pre-accident, complaints arose immediately, and then continued thereafter? You will be better able to manage the reserves of your customer. Utilizing the presumption in how you make decisions in a case can help defend against penalties and attorneys. I'm not accepting the bat. Better hope you win or you're going to get popped. I'm not accepting the bat because the complaints did not arise for 7 days after the accident, and I don't believe the claimant benefits from the presumption of causation. Okay. I had Pam Larimore sitting in this chair who said, Patrick, I would look at that, okay, because that adjuster knows how the game is played. Now, God love her, it's Pam. I can't say I would have won, but for her to sit here and say that I would treat that differently on a penalty and attorney's fee issue than the attorney just in the adjuster just saying in their claim notes, I'm not accepting the back, is significant. If you know how to use the presumption, even in your claim notes, in your claims handling, it may provide you a defense to penalties and attorney's fees. Okay. Court may say, no, I think the back is related, but I've got to appreciate the adjuster knows what they're doing because they looked at how the presumption would play out. Okay. Sure, you may owe for the back and that's going to suck, but it's still going to be a win if you don't have to pay penalties for your decision where you denied it. It also allows you to recognize when you need to get SMO in early. Okay. Are you dealing with a exposure limitation? It's an aggravation. They have the benefit of the presumption. We have an uphill battle. Is the pressure to get an SMO the same as in a case where you know they don't benefit from the presumption? Do you want to get an SMO early? Do you want to perhaps give your attorney an ability to pick a fight early, meaning I'm not going to approve the back? You get a 1008, you pick up subpoena power, and your attorney is then able to go dig up more information to show they can't meet their burden of proof at trial. Maybe you get a summary judgment. These are things that, unfortunately, for years, we try to give you usable training, try to give you quick reference guides, try to give you little snippets, tips, tricks that you can use. And looking at how that case was handled made me realize that maybe everybody, because I've seen other attorneys do this, that maybe it had been oversimplified. And that once we teach adjusters how to use the presumption of causation in their analysis, they will make better decisions for these reasons right here. They will use their time more effectively. They will be able to better predict the outcome, i.e. set reserves. It will improve their defenses to being tapped for penalties and attorney's fees. And it allows you to better use your resources. And when do I need the SMO? Look, in the day, you get your SMO as early as possible. But sometimes there's an urgency, sometimes there's not. It lets you better manage your claim before you are stuck with finding a way to get out of it. If that makes any sense. It allows you to take a proactive approach to managing that claim rather than going, I wonder if I can get my file count down by sending it to an attorney to solve. So that's presumptions, ladies and gentlemen. There is a lot here.